All right, shall we? Let me call the meeting to order. And is the mic on? You okay? All right. I just want to wish a very warm welcome and good morning to our visitors. Professor Angelo from New Zealand, who is also the drafter of the new civil code, Seychelles Civil Code. He is assisted by his associate, Sarah. Good morning. And of course, we are also in the company of our two Mauritians friends, Mr. Rosario Domingue, CEO of the Mauritius Law Reform Commission, and Mr. Sabi Cadel, Senior Law Reform Officer from Mauritius. I would like also to welcome Mr. Frank Ali, who's the Attorney General, and like last year, he will also be taking part in the discussion and taking notes of the different amendments and so on, and so that we will have something properly drafted, and that will be sent to the Assembly for debate and approval. I would also like to welcome Honorable Bernard Georges on the panel, who's also been a member of the committee who's been working on the Civil Code. Good morning and welcome also to the members, the Leader of the Opposition. I've been informed that the Leader of Government Business will be joining us a bit later. And like last year, we will go through the debate, the different articles and so on, and we will have the interactions between members and the panel. Moi, je suis content de dire bonjour tout le monde honorable et tout le membre du panel, et bonjour tout le monde qui est à l'écoute. Bon matin, nous pouvons faire sa session, encore une continuation de sa discussion que nous avons commencé l'année passée, pour nous regarder nos codes civils, et avec un but pour nous capables de gagner un code civil pour Seychelles, et qui va bien et qui va adapter dans l'environnement ici Seychelles. Et pareil l'année passée, nous avons eu très bonne réaction et dialogue avec membres publics, et moi je vais demander membres publics pour continuer cette interaction, les autres qui peuvent suivre nous, qui peuvent suivre ce travail que l'Assemblée nationale peut faire, tout en contact avec les autres membres, pas hésiter pour prendre contact avec les autres membres, pour envoyer un petit texte et pour partager un petit peu les autres conseils, l'intérêt qu'ils ont pour montrer dans la discussion, et les membres vont passer ça devant avec le panel à travers ce dialogue qui nous pour en this pour informer les membres and also for the panel. We will break at 10:30, our first break for tea, 10:30 to 11. Then we will break at 12 until 1:30 for lunch. And for today, once we start at 1:30-ish, we will go until about 3:30, 3:45, because North Region Council is meeting, and there's a special meeting with ISA at the Common Hall at 4 p.m., whereby 5 MNAs will be absent. So we will break between 3:30 and 3:45 for today, and then we can start again tomorrow morning at 9. All right, so this is a little bit of housekeeping work, what we will be doing today. We will kickstart straight away. I don't know whether Honorable George or even Professor Angelo has a few words to say before we start. Honorable George?
Thank you, Mr. Speaker. I join you in welcoming all the members to this second session of work, and of course all our honourable visitors and panelists. We have proposed that, given the work that we still have to do, that all being well, we should be able to have completed the second part of the code by tomorrow afternoon, so that we may not need to come back here on Monday. Because quickly reviewing it with Professor Angelo yesterday evening after the Assembly rose, we concluded that the work that is left, apart from what we call lawyer's law, is significantly less than last year. Professor Angelo has very kindly agreed to do a short summary of the work we've already done so that everybody remembers what we've done, and then set out the matters that we will be asked to review today and tomorrow. So without more ado, perhaps he can do that, and then we can get working.
Thank you, Honorable George. Professor? It's on, I think. It's only for the... Yes. Thanks.
Thank you very much, Mr. Chairman. Thank you, George. Greetings to the honourable members and to colleagues on the panel here. It's a great pleasure for Sarah and I to be here with you again. And we have very happy memories of the active discussions that we had 12 months ago, and we look forward to similar discussions this week. What the Honourable George has mentioned is that it is probably useful to have a brief review of what was considered in July last year. It's some time now since that happened. We did prepare a list of the proposals that had come out of that, and also a set of minutes. And following the request of this meeting, we also prepared side notes for each of the articles so that ultimately members will be able to have easier access to the provisions of the code, which in their original form are without titles. So those are some of the things that have happened since we last met. As a general matter, the revision of the code, the bill that's before you in first reading, aimed to basically to modernize the civil law of Seychelles, the basic law. And a primary objective was to make the provisions of the code compliant with the Constitution, and in particular with the human rights provisions, because you will remember that the code came into force before the Constitution. We also sought to modernize the language of the code. Much of the translation that is in the current law that is in the current law is in fact reflecting 18th century France. So there was a significant shift really between 1975 and the document you have before you. The review committee was also interested to structure the new code in the same form as current statutes. So it's a rather different drafting pattern. And we sought to have consistency of terminology. Now, as was mentioned last year, the bulk of the code in terms of its substance, its meaning, its subject matter, has not changed. Approximately 10%, however, has changed, and a number of those matters relate specifically to the family, and those were the matters that attracted most attention in the meetings last year. And what I would like, Mr. Chairman, briefly just go through what seemed to me to be the items that did attract the most discussion from the members last time, and it may be when the discussion of the code as a whole is completed that members may wish to come back to some of those earlier matters. The first that I have listed here relates to the role of judicial decisions, the judgments of the court. The current law says that one court judgment is not binding on another. The code introduces a proposal that lower courts should follow the direction of law indicated by the higher courts. So that is a significant matter for the consistency of the law and reliability and for the people who have to use the courts. In the family area, there were a number of issues which came up which were new, which would change the law. One is that the law relating to marriage has been brought into the code. During the colonial period, marriage was taken out and put in the Civil Status Act. For the integrity of the code, this bill reintroduces it, but the main principles are not changed. A matter of debate was whether there could be marriage of people under the age of 18, and there was quite a range of opinion on that matter. The bill proposes that in extreme circumstance, a judge of the court could approve the marriage of a person under 18. On divorce, in addition to the bill which reproduces the current law, there was a proposal from the meeting that a fifth ground for divorce be added, which was right to a divorce after 5 years living apart without reconciliation. Then a major issue related to the division of property when a domestic relationship ended. The parties split, and the bill continues the existing law for parties to a marriage if they're divorced, but increases the share of a divorced partner if the marriage has existed for more than 7 years. So it changed it from a discretion for the judge to saying a presumption of a sharing of half of the assets of the marriage. Then relating to the, you might say, the social circumstances and the demographics of Seychelles, there was a proposal that some of the benefits of property division for married partners would be available also to those living en ménage, provided the relationship was a stable and continuous one. And that was proposal was stimulated not only by the statistical information that the committee had, but also by human rights concerns, constitutional issues, and various commitments under international human rights conventions, treaties. And that had the advantage of recognizing the contribution of both parties to a relationship when that relationship broke down. Then in Book 2, there was the debated issue of droit de superficie, which is a court development, and the rules have been brought in to the bill, and the endeavour there was to stabilise the law. The judgments in the court show there's considerable divergence of opinion as to the true nature of a droit de superficie. So there is a proposal in the bill that the droit de superficie must be in writing to be valid, and it is a right only for the person to whom it's granted. In other words, it is not an inherited, it's not a right that can be inherited. Then I think we began in Book 3, and this is Articles 815 and following. And again, a very important matter, relating to the fiduciary. This is where there is co-ownership of land. In 1975, the aim was to deal with the problem of extensive fragmentation of land. So multiple owners of a small portion of land, particularly where if each wanted their piece of land, they would end up with a plot that was of no commercial value because too small. The current law is contradictory. The courts have struggled. There are provisions which say the fiduciary is the owner, and there are other provisions which say the rights of ownership of the co-owners are not affected. Well, those two don't sit together very well. And also the provision that the co-owner's interest is only an interest in money, not in land. The proposal, the way the committee sought to improve the situation, resolve the differences, was to say no fiduciary is needed unless the parties disagree. They may be happy to have the land remain in division. Further, if they do not agree, then there should be a fiduciary appointed, and the job of the fiduciary is to inquire of the co-owners whether any wish to buy the shares of the other. In other words, to, if you like, maintain the inheritance, typically an inheritance, within the family. And only where it is impractical or no one wants to do that will the land have to be sold, and the co-owners will get their cash share. So that's in terms of the court, in terms of land use, a major proposal to clarify the current law. Then on succession, the major issues, I think, were the equalizing of the rights of all children. The current law discriminates against the children of an adulterous relationship. The proposal is all children should be treated equally in terms of their rights to succession, for instance. Then significant proposal in relation to succession generally, and that is that if a person makes a will, they should have testamentary freedom. They should have freedom as to whom their property goes. At present, the right to dispose of property by will is restricted by the reserve shares, what is said to be the quotité disponible is limited primarily on the basis of the number of children that the deceased leaves. That principle in itself may be said to be unfair, and we have in the code a provision to say that there is a right for continuing maintenance for all children, parents, and surviving partner if they were living with the deceased when he or she died, and they were dependent on that person. So there's a shift away from the reserved portion to testamentary freedom, but offset by the provision, if you like, for family, for protection of the close family, but on a maintenance basis. And then I think we're almost up to where we stopped, which is around Article 1101. We did have discussion which ranged across the bill, because many of the issues, such as those relating to emménage, in fact, relate to many, many aspects. So we dealt with them as subject matters rather than by articles in many cases. Now, looking forward then, the matters I believe that were not developed July last year, and which are probably of some interest to the members, relate to back letters. This is contralet. There's been some reform suggested. They are provided in the code, but again, the current provisions are contradictory in respect of contraletters and land, and the bill seeks to resolve that. Then the requirements 1341 for the requirement of written proof for transactions. The current limit is set at 5,000 rupees, and of course in 2019 that's not such a large sum. If you have to have writing for every transaction of 5,000 or more, and the proposal is that that evidential limit be lifted to 50,000 rupees. Then the current law, but in the court cases, is the matter of trouble de voisinage. And that has been brought into the code under the provisions on délit, and that's at 1389. And then finally, I think, is the law on lesion, where there is an unconscionable bargain. Someone acquires property for less than half its value, that the transaction can be challenged. The law on that is primarily in Article 1674, and the law has been clarified and tightened. Mr. Chairman, the bulk of the bill that we didn't address last July concerns contracts, and that there's really no substantial change. Just the standard formatting and so on is the main change, and there are 12 different types of contract elaborated, so there's a great deal of material there, but no substantive change. So it deals with sales, exchanges, loans, leases, and guarantees. All those matters are in the second half of the book. So what I've identified there, Mr. Chairman, are 4 or 5 matters that haven't been addressed in the earlier sessions, which, along with any other matters the members may wish to discuss, I believe would warrant warrant being addressed specifically. Thank you.
Thank you, Professor. Apparently yesterday somebody told me that if it's possible we can go back to 815, Honorable George, where ownership, where somebody raised the issue of ownership. You? Yeah?
Fiduciary.
Okay. I don't know whether we can go quickly through ownership, co-ownership. Yes? Yes?
Yeah. Yeah, got it.
Short. Okay. What we'll do is there's a few queries coming up from the floor. We'll tackle that, and then we'll go hopefully quickly through ownership and all that, and then we'll go to contracts. All right, Honorable Rankalawan.
Thank you, Mr. Chairman. And I also want to be welcome to all our members of the panel. Mr. Chair, I just want to go back on the issue of marriage and the age. And I want us to bring out 1 or 2 points to argue that, in fact, Seychelles should use the opportunity, as we are amending our civil code, to fall in line with the charters that we have signed. Seychelles has actually committed itself to eliminating child marriage by 2030, and this is in line with target 5.3 of the SDGs. 2013-2014, Seychelles co-sponsored UN resolutions on child, early and forced marriage and signed a statement. 1990, Convention of the Rights of the Child, which sets the minimum age at 18. 1992,
Convention on the Elimination of All Forms of Discrimination Against Women, which obligates states to ensure free and full consent to marriage. And the age of consent is, of course, 18 or 21, whichever case. 1992, Seychelles ratified the African Charter on the Rights and Welfare of the Child, including Article 21 regarding the prohibition of child marriage. 2006, Seychelles ratified the African Charter on Human and People's Rights on the Rights of Women in Africa, including Article 6, which sets the minimum age for marriage at 18. 3rd June 2016, as a member of SADC-PF, Seychelles approved the model law on eradicating child marriage and protecting children already in marriage. So I find it, the point that I'm making is, should we not state clearly that 18 should be the age? And I mean, I don't go for those exceptions. I don't go for those exceptions because by doing so, we are not protecting mainly the girl child. And this is an issue which, as a member of SADC-PF, which is constantly brought up, and right now we are in the process of ensuring that all member states of SADC-PF actually change their laws, and there's a lot of work being done. And I think by stating clearly that the age of marriage in Seychelles shall be 18 years, we will in fact be not only signing charters, but we will be showing that we're putting our money where our mouth is. Thank you very much, Mr. Chairman.
Honorable George.
Thank you, Mr. Chair. This proposal, of course, is one which we debated last time, and it is one which, if you look at it in the context in which the Leader of the Opposition has framed the issue, it's perfectly acceptable and normal. But it does not reflect the reality in our country, where people don't get married. If everybody, you see, in most countries, people get married. So the issue is live. In Seychelles, most people don't get married. So what we're dealing with here is 20% of the population. Everything that the Leader of the Opposition has said affects 20% of the population, doesn't affect 80%, who don't get married and who start families well before the age of 18, in any event. So while his proposal, I think, is perfectly acceptable, it only goes up to a point, up to a very low point, because it does not affect the bulk of the population. And one of the main problems that we had when we considered issues of marriage, partnership, emménage, and succession was this: should the civil code direct the way in which our lives should be led, or should the civil code recognize the way in which our lives are led and make appropriate suggestions? I think this is the issue which is at the core of this debate.
We have this debate also in the perception of each it's possible for a minor, not so tendencies, a girl with marriage and who's what we call emancipated by marriage. So right now, there has been, as you rate, human rights commitment saying to protect the rights of the child, should the child, instead of getting married, should be in education at the age of 18. But if she has children, fair enough, but the implication is still thinking of getting married. She can, in the future, be a 16 person, get married. And right now in Moses, there will be a child bill, and I know a policy decision has been taken to make private marriage under 18, to make it in conformity with the human rights requirements. That's one thing. Second thing, which is different, around life of people, it is mainly because of that we must intervene to put the age for sexual divorce at 18 to be lowered. That's something different. That's something different. Yeah, in France it's 15. That's something different, which assessment of discernment which we have. But the idea behind it is odd. In the old days, women were not sent to school. She's starting her life of leading children. Yeah, that's all. At that age, people, girls like boys, have an ambition to do it. So you can have time in the future. Get married. You can have a provision also. There is no difference anyway between whether the child was born, the parents were married or not. We have now a law, you can legitimize by people married, but that doesn't change anything to you. Because the rights are the same, as if the parents were married or not, the rights of the family are the same. It makes sense to do that way. It's difficult to imagine how a judge would consider it in the best interest of the child to allow the marriage. Very often it's trying to save the honor of the family or something like that. It's a very old values that we have taught in these started with 48 and so on, about human rights. Very old values. It's 48 years of the Declaration of Human Rights, and it's more than just the child, the human being. That's a policy decision. Okay, but it's an indication that in many countries they are moving along that line. The child is married in the 18th of age.
Thank you, Mr. Dumain. AG, let AG have this.
Good morning. I think the Assembly should be alive to one issue, because I don't recall any provision with regards to that the unmarried relationship, when it starts, because marriage entails legal consequences. So if we are to give unmarried relationship more or less the same status, then the civil code, if it says you can't marry, it should say also you cannot start an unmarried relationship unless you're 18 years or above. Now, if somebody, and as Honorable George has said, we have to look at the reality of the country, whether we now want to use the civil code to be more prohibitive, and therefore, if any person has entered into an unmarried relationship prior to reaching her, especially the female, has entered into an unmarried relationship, then the period from, let's say, 16 or 17 will not be counted and will not have legal consequences. So this is something that we have to, and we need to look at whether by providing for it, greater prejudice and hardship will be caused to that person rather than otherwise. So we need to be, you need to be alive to this, because as I said because this is a law that you will have to pass, you will have to live with, not anybody else. And then it's for the population then to become the code of everyone. See? And as Mr. Dominga said, yes, the court will have to look at what is the best interest of that child, and whether it is to save the family order, or whether it is to, but very often, there is not only that person, or the parties to the marriage, there is a third person, and that is a child. And if we are to, I know the code is trying to give equality in terms of status to all children. So whether you are adulterous, whether you illegitimate, etc., if there are, then this child also would have to be looked at. Thank you.
Thank you, Echi. Honorable George.
Thank you, Mr. Chair. I think the issue has been encapsulated. So far as is possible, I think it is desirable that people should be encouraged to enter into relationships, whether it's marriage or not, after the age of 18. I think this is an aspiration which we all should bear in mind. The current provisions in the Act and in the Code now, which allow for derogations from marriage above 18, are essentially in cases, they apply in cases where generally the girl falls pregnant and below the age of 18. And if we prevent marriage with the consent of the parents, or in default of the consent of the parents with the consent of the court, below the age of 18, what we are doing is we are forcing people who fall into that category not to marry, despite the fact that they are in a relationship, and then to marry after they get to the age of 18, which is tantamount to preventing them from getting married at all, because having lived for a year or two in an homme-ménage relationship, there is no incentive for them to get married. That is, I think, why there is this provision, this échappatoire in the code. Statistics, on the other hand, and now this supports the leader of the opposition, statistics have shown that whereas one marriage out of 3 fails in Seychelles today, does not reach, is not dissolved by death, but is dissolved by divorce, 1 out of 3, getting close to 1 out of 2, almost 100% of couples who get married with consent below the age of 18, almost 100% are divorced at some point. So the marriage has got a greater chance of failing if it is entered into below the age of 18. So that is one reason to push the age back. The problem is we're talking about legalities. The people out there who are having sex and who are getting into a relationship don't care about legalities. They get on with their lives anyway. And this is I think, the core issue. How do we, as legislators, through this civil code, educate and inform the people out there? Do we? And I like the use of the word prohibitive earlier by somebody. Do we restrict in the code? Do we restrict, or do we become more permissive? What is it that we want? Do we want a code which restricts, or do we want a code which permits? And I think this is one of the questions we have to answer.
Honorable Runkalawan.
Mr. Chairman, thank you very much. The point has been well explained, and of course, one can argue on either side of the point. But I think what Mr. George Honorable George has talked about touches on the essential point that there's got to be some form of serious education on the issue. And I can tell you that, well, I only wish I had brought the booklet, but it's in the office and I will bring it at some point. I can tell you, if there is one model law where SADC PF has done a lot of work on, I mean, it's produced all manner of manuals and everything, is on the protection of
the girl child, and of course, marriage at the age of 18. So, in a sense, you mentioned the statistics, but are we not at the same time, by discussing what we are discussing, also trying to help raise the standard? And I believe that if the law can help us to do that, then by all means let us do so. And the various issues, age of consent for sex, which is today 15, but on the other hand, not being able to get contraceptives until the age of 18. All these are the contradictions and issues that, as a country, we will have to tackle. But I think with where it concerns the protection of the girl child, Seychelles has an obligation to fall in line with the conventions that we have signed, and for us then to be able to do something extra. Honorable Aglai and myself were at the meeting of the chairpersons, and we were impressed. I mean, I don't want to speak for the honorable, but I can tell you we were impressed with the work that was being done. Because sometimes, as we look at our local situation, we must not just say, but we're okay, I mean, the kids are getting on with it and everything. We also have to bear in mind our role in the region, for example. We have an important role. And countries which are facing major issues should be able to look up to us and say, but this is what they did in Seychelles, and therefore we can use Seychelles as a model. I think there's this regional leadership role that we also have to place before us. There is the raising of moral standards, and so I think we've got somehow to put all these things together. This is the basis of my argument to saying 18 years old, and okay, I know these things are not happening today, but when 13-year-olds were being given away simply because because there was a rich Englishman who had seen this beautiful girl, and we said, well, we signed the consent and everything else when this guy was a pedophile. I mean.
Yeah. So, I think we have a consensus, no?
Yeah, point is made, and I
point
think,
is made.
Mr. Chair, if you will permit me, all of these points, because everything now is going to go after we've discussed all of this, and this is a very interesting discussion. We'll go for second reading at some point, and the Bills Committee will have to produce a report highlighting all of these points and raising issues such as the one that has just been raised. And Professor and Sarah have very kindly offered to help with the writing of this report. So this is one of the issues that will be highlighted for debate on the floor of the House and for a decision to be taken. But I think the point made by the Honourable Attorney General is very good. Professor Sarah, if you would note that, if we make the exception, or if we make the rule for marriage, then we have to make the same rule and discount any relationship prior to 18 where the parties do not get married. So we don't count those years towards the 7 years for the property division.
Right.
Mm-hmm. Okay, thank you very much. Yes, Honorable William.
Chair, I just wanted to especially on what the legal proposal have been putting forward. I mean, do we have any contribution from the religious groups with regards to this? I mean, I just want to know if whether we have had any opinion coming from the different religious groups, because it's very important for us as members of parliament to know what are the inputs on that, especially when we are talking about moral values. I think.
For somebody from religious group to interact, but so far nothing.
I've already got one.
You've already got one. But probably Honorable George is a better place to answer this, because this project, this work has been going on for a while. I'm sure even CIFCO probably has been interacting and all that. I don't know. Honorable George, during the white paper stage, was any religious group involved, or is CIFCO?
Yes, yes, indeed. CIFCO was present, and and relatively vocal in their proposals. In fact, they've sent a paper. We have a collection of representations that were made, and these will be circulated. All members, by the time we get to the second reading, will have all the information that we can provide.
Thank you, Honorable George. Honorable Lemiel.
Mr. Speaker, if I have a comment from somebody in the district, can I share it?
Yes, of course. This is a dialogue between us and the public also.
So I have received a text from someone saying marriage is a very demanding commitment which should be made only when the considered people are ready for it, and not just because they have reached a certain age. There are a million other variables other than just age. It's about being mature enough for the responsibilities of a marriage at any age. Age is not necessarily the objection. A 30-year-old can have a bad marriage. Marriage is a big commitment. You are choosing to be someone's for life, and everything that goes along that. So the person says that this is her contribution towards our debate.
Mr. Speaker, unfortunately, this is a very good text for a marriage sermon, but it's you cannot measure it. If you're trying to put maturity in the law, how do you? I mean, you can only go with an age. So it's just like voting and everything else. But it's a very good, as I say, I mean, I've blessed marriages, and probably I've said these things in many sermons, but
And I think the comment also probably when the person mentioned maturity also. The person was also speaking against getting married, getting engaged in a relationship too young. So this is why we are also discussing of setting a certain age, which we are considering 18. And of course, the SADC region is actually moving forward at quite a good speed with regards to this eliminating child marriage. And I think the region is moving faster than the rest of Africa, because in certain African countries, this is still taking place. The girl child is not being protected, okay? And girl child are still being, I don't know, sold for a number of heads of cows and everything. So it's still going on in certain African countries, but SADC is in a position, I think, by now, most member states of SADC are saying no to girl-child marriage and all that. So I think we are in a good position right now. What we're saying now is to also put Seychelles à jour with all the conventions that we've signed, we've ratified. Okay. So
one final word,
yes,
if you will, and I need to sound this alarm. I think we all agree with the proposal made that we should enforce some kind of discipline and order in marriages. But we are still talking about 20% of the people. We have to talk about marriage because this is what the Civil Code talks about. But in fact, our problem here is not child marriage, it's child sex. What we should be addressing is educating our children, our parents, our societies, to stop having child sex at the age of 12, 13, which is rampant, and entering into relationships at the age of 14, or just having a number of multiple relationships. That is the social issue which is of more concern than the age at which people should get married.
Thank you. And I think what Honorable George meant and Mr. Domingue, this is the age where the child should be concentrating on studies and not on having a sexual relationship and so on. Shall we move on? Did you say you have another point or no? Okay. We will revisit droit de superficie because AG mentioned something to me earlier. Do you want to open?
Okay. I was not present when the discussions on droit de superficie, but I think it has been thoroughly discussed. But I need to share one issue. What the code
Article 554 in the booklet. 554. Yeah, sorry, AG.
Yes, so what the code is proposing to do is to make a droit de superficie a personal right, as opposed to a real right. If my memory serves me right, the jurisprudential development is more like a droit de superficie becomes a real right. You have a real right to that property so long as the building that you have built on the land covers the land. Now, the development in Seychelles with regards to droit de superficie, which is, as I said, as Professor said, is more case law, developed by case law, is under the Land Registration Act. A lot of people, a lot of proprietors of land have given a right to build.
Permission to build.
Yes, what they call a permission to build, or a right to build to a third party, a member of family, etc., etc. And very often this right will more or less becomes permanent. I remember a long time ago, myself and Honorable George, who were in a case where we were seeking a declaration because that person had built with some form of express consent and said, I want the court now to declare that I have a droit de superficie on the property. Under the Land Registration Act, what a lot of people, as I said, are registering a permission to build. And this is their life. This is their life investment. And they are given a loan, often the proprietor, who is a parent or a close relative, would charge the property in favor of that financial institution or lender for the person to build. Now, if the person tomorrow who has a family drops dead and the right is personal, then that person may lose, and the family may lose the property. So it is something that maybe we need to consider in the context of the reality of Seychelles. So this is only a contribution that I want to point out to you, so that when you discuss it further, it's something that we have to look at. Thank you.
Thank you, Mr. Chair. The Attorney General makes a very good point. The current law is jurisprudential. It doesn't exist. In the current code, there's nothing called the droit de superficie, as the professor earlier mentioned. What has been done by the Civil Code Committee is to turn that jurisprudence into Article 554 and make it a statement of the law. So we don't have to go to cases about droit de superficie, but we have a statement here. But what it's done, as the AG says, is the committee has not followed the jurisprudence. Jurisprudence is clear. A droit de superficie can be passed on to heirs for the reasons that he has given. A droit de superficie is a droit to use the superficie of the land, but you never become the owner of the land. You are the owner of your house and the right to enjoy your house on the land, but you never become the owner of the land. So it's a minor right, but it is an important one nonetheless for the reasons given by the AG. The proposal before us is to change the jurisprudence and to make that right personal only to the person who has built, and it has problems, such as the Attorney General has mentioned. I may say now, I've mentioned it to Professor Angelo, and he's well aware of that I am, as a member of the committee, I did not support this proposal. I wanted to remain with the law as it currently stands. So when it goes to second reading, I'm going to propose amendments to what is currently here to bring them in line with what the Attorney General has already said, because I feel that we've moved so far and that this is a regressive step.
With the permission of the speaker, maybe I can just make another major point, is with how you get that right. See, the proposal is that it has to be in writing. Now, a lot of people who's got that, what is superficie? Sometimes it's not in writing, and depending on the manner that the right is given, it can be purely oral, or it can be, and for example, between parents, between close relatives, then the rules of proof will come into play. Because if there is a moral impossibility for me to get a writing, my mother simply tells me, "Mon boy, and then I have to bring in that moral impossibility for me to get a writing." The same applies, for example, if I have, long time ago, I did a case where somebody got a permission to build on the land of another. And as he said, moitié travail beau, il y a vraiment une travail zone, and then madame il donne moi permission, moi fais moi la case là. And he built. And now the purchaser comes and said, "You get out." Now, because he got it from another person, the purchaser, he can always use the oral permission to claim that right. So, to make it purely to be strictly written also might cause a lot of problem. And sometimes the owner, because he owns the property, has to apply to planning authority for that building to be erected. But they may have some form of agreement between them. It can be oral or it can be in writing. Just
And before you speak, just so that everybody knows, what the Bills Committee will do in this case, because it is a contentious issue, is to give an alternative draft so that members can decide which one they prefer when we vote.
Okay, let me give Honorable Supura the chance to. Then Honorable William, and then Honorable Ferrari.
Thank you, Mr. Chair. My question has been, Mr. Ferrari answered part of my question. Do you mean that when we say writing permission, it's a sort of an affidavit that we need?
any document.
Any document.
Any document. So long as it's clear that the permission is either expressed or implied, but it is a permission to make.
Permission. But now in Seychelles that we are giving people permission to have second house built, don't you think that this will cause a problem in the future?
if we do it the way it is proposed, it will cause a problem. See, in fact, I need to revisit from my discussion with a colleague. In Belgium, the real right is for a fixed period of 50 years. So it's more or less akin to a lease to some extent. But it will, if you're giving somebody a second house, then that second house is to a third person, who may be a member of the family or a third party, then it will cause a problem. Because when that person dies, then all the rights will vanish. And he will not be able to, his heirs will not be able to inherit. It will go to the proprietor of the land. Sometimes it's tidier things because, you see, if you've given somebody a permission to build, and then you need to charge your property in favor of a bank to get a loan, the bank might tell you, in order for you to charge mortgage your land for me to give you a loan, that person who also have a droit de superficie should also give his consent, because if tomorrow I move in to enforce my charge, I want the whole property. I don't want to have your house or your vacant land, but that person who has a droit de superficie said, okay, you buy the property, but you buy it with the encumbrance, and I am an encumbrance. And that you have, the purchaser has to live with. So this is where sometimes when somebody gives a droit de superficie, he needs to, or right to build, he needs to seek legal advice to understand the consequences. Because if you have an unwilling person who has that right or interest, you may not get a loan because the bank will say a loan is subject to that person also giving his consent to the
Thank you. Before we continue, we are getting some complaints from members of the public that they would also like the debate to be in Creole. Okay, so members, please do not hesitate to use Creole because the panel is all right with that. We can translate a bit and help Professor, but please do not hesitate to use Creole, okay? Honorable Sofola, you through?
Yes, I'm okay, thank you.
Honorable William.
Mr. Chair, this is not very
Just 1 second.
From Sarah.
Bon, ça va, cause on donne consentement, là, mon frère va enregistrer dans la télé, on sait, là, par exemple, I know perfectly pour ça, mais si les mêmes say, moi, après tout le monde say, dit, let me have right to la case.
attorney avec un manager aussi, regarde ça. Aujourd'hui, le gouvernement peut build un block of flats. Ils ont 3 blocs. Et ça dit, on qui est en Bali, il enjoy sa bout de la terre. Mais comme si on regardait sa bande qui en l'air aussi, des Britanniques en droit, le sa bout de la terre. Mais moi, senti pour dire, par exemple, si y a une bande qui peut louer ou une bande qui peut acheter, finalement, le gouvernement m'a croit besoin de revoir à cause de la regarder si on peut vendre, sa bande qui a l'air aussi des Britanniques même droit, qui ça a une carte. Mais aujourd'hui, on croit pour dire que les agreements pas vraiment définis. Et il y a un problème entre les résidents, ça bloque off là, à cause de ça en bas, qui peut résoudre sa bout de la terre, mais en l'air libre, son enfant pas capable de jouer en bas. Ce moment, pour dire ça, dans l'avenir, nous avons besoin de ça. Merci. On est la loi. Mais seulement, pas défini bien.
Il gagne un registre en bas, it's registered under the Condominium Property Act. Now, under the Condominium Property Act, you have the common facilities or common areas that should be enjoyed by everybody. So, the person who is in the unit, he owns only the unit, he doesn't own anything else apart from his own unit. Everything, for example, the staircase, the roof, exactly. Everything is common areas that no one should be enjoyed by everyone.
Non, mais seulement, la réalité aujourd'hui, c'est que ça demande pas son petit flemme, son barrage qui fait que les autres ne peuvent pas enjoy. So, unless.
The management corporation or the person who manages it, because every condominium management corporation, and it is the role of the management corporation to prevent this from happening. But however, we have to be cautious that not all property of this kind has been registered.
Yeah, invoice. Yeah.
And often the property is leased. So the lease is original, that's the unit. The rest, the common concept is for enjoyment by everyone.
Nous voyons ça un petit peu même, nous faisons une visite tout récemment glacée. Quand tous les autres monde et quittent ça en bas pour lui occupe sa common area. Et personne ne les prend pas. C'est dans zèbre en bas. C'est ça en bas qui est coupé, qui est nettoyé. Ça va dans l'air, dit ou non, staircase. Ça en qui peut sentir pour dire sa staircase est sale, qui affecte lui, qui est next door, c'est lui qui est nettoyé. C'est une question là, ici c'est pas ça staircase est monté. Mais c'est ça peut-être pareil et Jean dit qui laisse sa bonne propriété qui est registered, c'est ça management qui besoin exécute ça la loi, qui besoin faire ci, qui ça la loi il peut appliquer, pareil il devrait être appliqué. Mais par exemple, nous avons dit, on très bien plusieurs situations, ça est en bas, il prend sa petite common area, il fait son petit back garden, il fait son petit front garden, à cause c'est lui qui met tenir. Pour le moment, il est comme ça.
Et ça qui pire, c'est que ça a un qui en l'air, les tanks de l'eau overflow, lui qui gagne flood. Lui, non seulement, il n'a pas un garden, mais il peut mieux pour gagner flood lui-même.
Et aussi, une couverture, toiture. Et nous voyons dans la visite glacée récemment, il y en a tenants qui ont vu son toiture, mais son toiture, il va là plus à l'autre côté. Et il n'est pas capable, c'est à l'autre côté, il dit non, ou pas qu'à changer toiture que je ne peux pas affecter pour moi. Voilà. Et là encore, quand nous peut dire que management, c'est un appartement, c'est un condominium, il veut rentrer avec quelque chose qui est clair. OK? Honorable Ferrari.
Oui, une situation loi qui existait pour le moment sans aucun document. Beaucoup connaissent bien la loi marché, mais est-ce qui par exemple, si ça droit qui ça dit on peut exercer l'eau ça bout de la terre, pas grand challenge, est-ce qu'il vient de droit qui? Ça est mon premier point. Mon deuxième point, c'est le enjoyment pendant un certain temps. Qui me croit qu'il fait sens. À cause si propriétaire sur la terre, il donne nous droit pour jouir ça, mais pas devant nous, c'est qu'il donne nous ça droit pour un certain temps. Pas pour. Sinon, si tu as envie de nous pour tout le temps, il est devant nous. So, quelquefois, les temps, non l'année, il devrait être, par exemple, dire en Belgique, gagne considéré. Merci.
Merci, honorable Ferrari. Et tu?
Mon point, c'est une question que l'honorable Georges est très content de répondre. Il y a une question en fait qui nous fait nous dire, quand nous tirons en cours, tout le temps, c'est sa propriétaire, il tire sa occupier, qui présente sa occupier, il raise the fact que mon aide doit aller superficie. So il vient par nous dire un shield plutôt qu'un épée. Mais qui nous fait, qui dit qu'on n'a pas de superficie qu'à faire, c'est à l'encours de demander un gisement déclaratoire pour dire que la cour, to say to the court that I want to declare my rights, my droit de superficie. Mais ou pour seulement un droit de superficie. Mais au besoin qu'à premièrement prouver pour dire que tu as un consentement. Otherwise, on a la loi qui peut prendre en considération là. Ou pour qu'à rien tirer, dépendant sur bonne foi, mauvaise foi, etc. Ça, the law is remain will be applied. Bon. Un droit de superficie, si vous pouvez dire que vous gagnez une permission, pas qu'à appeler de prescription. because prescription, il y a un petit assist to une permission. So, si un dit, il peut c'est prescrit, ça veut dire, il peut dire, mais mon zoui sa propriété pour plus de 20 ans, nous avons une prescription plutôt 20 ans, qui en France, il y en a 30 ans, Maurice, 30 ans aussi, pour tout de mauvaise foi ou une bad faith. So, vous pas capable, ou pas qui par prescription, à cause où tu en as une permission. Par contre, si tu n'as pas une permission, là, vous êtes capable de prescrire, ou capable faire une action pour prescrire. So, et pareil, il dit, mon quoi, vous êtes capable by agreement, agréer, pour dire, ou pour faire au bâtiment l'homme propriété pendant tant l'année, il vient un petit peu varier lisse. Et après ça, on a décidé lesquels qui pour payer lesquels en termes de sa développement.
Ok, merci Edgy. Honorable George.
Pour répondre à Honorable Ferrari, until assez récemment, dans sa dernière 5 ans, quelquefois, jurisprudence qui dit qu'il y a un droit de superficie, il y en a un la fin. Et son la fin, c'est sa bâtiment il besoin de réparer ou bien reconstruire. C'est-à-dire que vous pouvez rester. Et ça, tu marches très bien dans l'époque quand on droit de superficie. Tu mon boy, ou bien mon garçon travaille pour moi pour tant en temps, mais toute la case dans un coin propriété. Tu as la case en bois, obviously, à un certain moment, il a besoin de réparer. Alors, tu dis, on doit en arriver à la fin. Mais aujourd'hui, là, on fait toute la case en bloc avec. C'est pas ça, mais arrive sur la fin. Ça nous besoin de revoir sa période et nous revoir aller en perpétuité. Quelquefois, nous besoin d'arriver à une accommodation entre un et l'autre. Mais ça, on va décider.
Merci, Honorable George. Honorable Chantal Guissin.
question pour faire avec sa doigt là. En ce moment, il était là. 3 cabanes dans la case qui peut construire l'eau ban la terre. C'est pas ça, ça part, on donne ses enfants, soit un monde pour. Et les wall côté chef si pour gagner loan, il exige qui a sa letter of permission qui gagne enregistré and stampé and everything. Et ce qui avec sa lettre là, en ce moment là, nous peut dire pour bénéfice public, qui peut écouter, nous peut dire qui pour arriver à un certain état, un certain moment qui sa lettre ou ça même si elle a sa lettre, il peut arriver problème dans le cas côté zo ça la terre gagne vendre. Est-ce qu'il comme ça ou soit qui manière ça pour masser?
Bon, il peut dépendre ça la grande pour faire. En fait, les nous peut causer de Honorable George, il y a un conseil qui m'ont pas nous partager. Beaucoup l'enregistreur a enregistré un document qui avait la permission to build.
Yes.
Question c'est, il n'y a pas un document qui la loi d'enregistrement il permet de enregistrer. So, la question c'est qu'il y en a une autre provision, on appelle ça un overriding interest. So, il y en a un interest dans sa terre, alors il a enregistré sa interest. Il faut des interest qui existait. So, mais qui peut arriver, c'est qu'il y a un enregistrement, l'enregistreur, il peut enregistrer sa permission to build. So, il peut pas de problème selon qu'on dit, et on met condition là. À cause, si on ne peut mettre aucune condition, on peut donner l'impression qu'il faut en perpétuité. Mais la Cour saisit avec un issue pareil. Il peut avoir provision civil code. Et ces provisions civil code, il pourrait être traité comme le droit commun. La loi qui, to some extent, régule s'il n'y a pas aucune inconsistency avec ça l'agrément. So, mais mon pas quoi, vous dit, il y a un problème selon qui ils ont fait une provision de duration, de conditions, etc. Pas estimé de nouvelles permission. Otherwise, this might override tout quelque chose. À cause, c'est le code qui est capable de mettre, il peut interpréter de façon que, for past legislation, il pourrait s'il y a une inconsistency dans la législation antérieure, il et civil code, c'est civil code qui pour le préfère de son interprétation.
Merci. On regarde en termes pratiques. Et là, moi, besoin de défendre sa proposition qui, dans sa civil code, qui vient d'un droit personnel. Décision derrière ça, c'était pour mener un sens pratique. Ou on vit faire la case loin de la terre. Ou aller où la terre pas pour vous, mais pour parents. Ou bien pour les amis. Et où elle demande permission et où gagne permission to build. Ça qui sa proposition peut faire là, c'est on regarde dans un sens pratique. Si vous avez envie que la case reste pour vous forever, ou pas pour dire que les parents, pas non permission to build. On nous subdivide, transfère ça à la terre au moins, moi quand je vais la banque pour mon loan hypothéqué, il va rester pour moi va quitter pour mes enfants, etc. Ou bien, loin moi, pour 99 ans, et là, moi, je vais gagner aussi un titre qui m'a pour capable de faire ça avec. C'est d'abord un cas quand ça dit quelque chose pas arriver, qui vient un personal right. C'est pour force du monde, pas en an, ça, à cause de ça, droit de superficie, il désordre. Il n'y a pas ni quelque chose ni l'autre. C'est même ça la loi a besoin un petit peu pareil, un just enrichment. Il a besoin de trouver une solution pour les gens qui fait la case loin bout de la terre qui partit pour les autres, pour donner aux autres un certain droit. Alors, ils ont quand même avec ça l'idée des droits de superficie. Proposition que peut faire là, c'est pour force du monde, pas faire permission to build, pas faire droit de superficie. Faire ça d'abord l'exception, pas faire les vins un palto derrière, pareil, y arriver comme il a qui est courant. Moi, mon fait droit de mon fait papier permission to build presque tous les jours dans mon bureau. C'était pour force du monde, pas dans sa situation de désordre, mais dans ordre. Subdivide, acheter, ou bien subdivide, louer, ou bien même pas subdivide, mais faire un liste loin bout de la terre, ou avoir un titre propriété. Et dans un cas où tu n'es pas capable de faire ça, là, il va venir un droit de superficie, mais il va exister juste pour vous personnellement.
Merci, honorable Georges. Honorable John Wow.
C'est un cas, par exemple, quand un diminue droit de superficie, mais après il mort. Et que o ban res e vient réclame toute part. Et dans ce cas, les autres réclament toute part. Ça dit mon li, il dit rien ne doit superficie pas sortir ça morceau la terre. So, moi crois nous besoin mindful aussi dans une situation comme ça qui est quite common et qui nous peut faire ça la loi, nous peut prendre en compte ça dans quelque chose comme ça aussi.
Pourquoi ça n'est pas pour un problème légalement, c'est un problème de façon pratique. Légalement, à cause des héritiers, sa propriété, il a besoin de respect dans la transaction, dans l'obligation qui sa propriété, il y en a. Parce que ce n'est pas ça du monde qui donne sa loi de superficie qui mort. C'est sa propriété. Mais sa loi, il continue. Et les héritiers, il a besoin de respect sa loi, ça dit. Mais la planning aussi, en général, planning est un rôle important pour les jouer. Et c'est ça qu'il voit, pour Georges dit, il fait une permission to build parce qu'il faut les jouer. À cause planning, now, il demande comment une condition, si sa propriété, sa building, il peut ou qui ont un document pour montrer qu'on est droit. Si on parle de droit ou droit de superficie, il en court avec les parents, bien ou ça du monde, mais sa permission, il donne sa propriété, c'est un autre affaire.
Bon, nous partons réaliser que le dialogue est intéressant. Nous dépassons nos lèvres que nous avons proposé pour nous prendre un break. Mais on va prendre un break. On va retourner. On va commencer avec Honorable Vidot. Et on va continuer un petit peu le droit de superficie avant nous bouger notre travail actuel. Ok, on va prendre un break, on va retourner, disons, 11h05, 11h10 comme ça. Merci. 11h, ok, on a grillé 11h. Oui, on a Oulola. Ok, thank you.